Bam.
Good evening.
Good evening.
Welcome to Courtside with Lawman.
And Carmen B.
And we are an educational and informational show. We are here to talk to you about issues that affect the public related to the criminal justice system and criminal law.
Yes. And we'd like to tell you that anything that we talk about and say and answer your questions, anything we do does not create an attorney-client relationship with myself, Lawman, or
with Carmen B. But we do encourage you to call in, to put your comments in the chat, and we will answer those questions for you. You can call in at 916-384-8204. Again, 916-384-8204.
All right. Friday night, and it's happening. What's happening? Well, we're about to go to school. We intend to produce and present to you what we call Criminal Procedure 101.
Now, I'm going to say before we start that, we talk about something major that happened with the federal criminal justice system.
And in the news today,
that is that the Attorney General, Merrick Garland, suspended federal executions. What that means is if someone is on federal death row waiting to be executed, those have been suspended. They will not be scheduling any executions.
All right. You know, California and Gavin Newsom did that when he came in.
Yes, he did a moratorium of the death penalty.
Yes, until we can fight it more.
And that's because it's not that we don't believe in people being punished if they engage in misconduct. That is not all what it means. What it means is because our justice system is not perfect, because our justice system is flawed. I'm actually not sure. We were on mute, so I am actually not sure if our viewers got any of that. If somebody could let us know in the chat if you were hearing us or not. I think I was in mute from my court appearance earlier today. So if someone could just comment in the chat, either yes, we heard all of what you said, or no, we saw your lips moving, but we heard absolutely nothing.
Well, just to make up, welcome, Lawman Carmen B here at Courtside. And we are here to answer any and all questions, hopefully around the criminal justice system. We do not create an attorney-client relationship if we do talk about your question. And you can call, yes.
You can call in at 916-384-8204. Again, 916-384-8204. You can call in with your questions. You can post them in the chat.
And we're going to go to school tonight, I said. We're going to do Criminal Procedure 101.
Yes, but before we get to that, we want to talk about a major change in the federal criminal justice system. And that is that the Attorney General, Merrick Garland, has suspended all federal executions.
Yay.
And what that means is they will not be scheduling anyone who is on death row in the federal system to be executed. And that is important, not because we don't believe in someone being punished in our society if they commit a crime, but we know that our justice system is not perfect. We know that it is flawed. We know that there have been innocent people who have spent years, decades of their life in prison for crimes that they did not commit.
There have also been people executed.
Yes.
So
executing someone is a final punishment. Even if you discover that they didn't do it, we have no way to bring them back. And that is why we are opposed to the death penalty.
Okay. So let's see. Anything else of news that we want to talk now? I know we're going to bring up the recent law changes again about administrative fees.
Because we just want to remind everyone, and in fact, I had a client who was sentenced today, and I believe the only fee that remained was the restitution fee. All of the other fines and fees were no longer imposed.
Yes, and I think they may be able to do there's a court building fee, I think of $30 or $40, but something around in there. That's pretty much it.
But no longer that,
probation report.
Yeah.
Work furlough,
the monthly
work
cost
project,
of probation, all of those fees are gone. If you're someone who was paying those fees, you no longer, it applies
Yep.
retroactively. So you no longer have to pay those fees. Now, you don't get your money back from the fees that you had paid,
Right.
but you no longer have to pay those fees. We just wanted to remind everyone of that. So if you're in California, you know someone who is on probation or parole, and they're doing work project or they're doing ankle monitor, remind them, inform them that they no longer have to pay those fees.
Yes. And also remind you about AB 1950, the section that cuts down probation for felonies from 5 years to 2 years and cuts down misdemeanor probation from 3 years to 1 year, barring some other things that aren't that are excluded, some
Yes.
crimes that are excluded, which are mostly domestic violence, sex crimes, and that's pretty much it.
And for felonies, the
serious
strike
and violent
crimes,
felonies,
serious
sure.
and violent crimes, there can be a longer probationary period.
Exactly.
But any of the other general felonies, if you are still on probation and serving a 5-year sentence here in California, a 5-year probation term, not sentence,
Right.
probation term, you can get that reduced to 2 years.
Exactly.
And if you've already done 2 years, you can get that probation grant
Terminated and then
which
get the
means-
case expunged immediately.
Yes.
All right. So we get to talk about what we do on a daily basis here. So we're going to try to go through the process for you. Okay. We want to give you a few pitfalls and ideas and things to think about if you are navigating yourself through the criminal process, meaning criminal procedure and the criminal behemoth monster, the court system. So to start off, Carm, you want me to start?
Sure.
All right. Well, the first thing that happens to an individual is they get arrested. Okay. There's got to be some sort of arrest.
They get to wear the bracelets.
Yes. Now, the rule is, am I free to go if encountered by officers? And if not, I want my lawyer.
And that is it.
That's it.
Provide your name, your identification,
That's it.
but nothing else.
And the reason you do that is to prevent law enforcement from taking advantage of you.
It is to protect yourself and to protect your constitutional rights that you have as a United States citizen.
Exactly. Now, at that arrest, it's always best to just comply, shut up, and roll with it. Eventually, you will hit a county jail. And when you hit that county jail, know that within hours, there will be an assessment done as to your ability to be released right away. And when they do that, you're either released and you'll come back for the next part, or you'll sit for no more than 48 hours and you'll be brought to the court. So your arrest procedure is easy.
Let me add right there, because of the pandemic, the time period for arraignment was extended. I believe it was extended to 7 days.
Yeah.
So people were no longer being brought within 48 hours. But I believe the California Supreme Court
Oh, yeah.
ordered that it would be 7
It could be
days.
up to that. Yes. Now, I'll tell you, things have changed, though, because the COVID procedures, that was really to protect against COVID spreading and stuff, the quarantine periods and stuff.
They are still doing the quarantine periods, because I did have a client who was in custody, and they placed him on quarantine even from being allowed to receive visits from friends and family members.
Wow. Okay. Then it's still going. So that's your arrest point. So once that occurs, once you're either appearing in court or you're appearing from out of court, what happens?
Can I throw in one other little tidbit that
Sure.
might happen to them after they're arrested?
Ah.
So normally, as Lawman stated, you would be taken down to your local jail, right? But there are times when law enforcement wants to interview you. So instead of taking you to the local jail, they may take you to a police station, which has interrogation rooms. They may place you in a room and attempt to interview you. What do they do in that circumstance, Lawman? What do they do?
Well, since you said you want your lawyer at the scene, they shouldn't take you there in the first place. But if you happen to forget that and they say they just want to talk to you, they just want to chat with you, and they bring you into one of the substations, Kenny or whatever it is, any one of those, and they want to bring you in and talk to you, you should follow the same protocol. Am I free to leave? And they'll say, no, in fact, we arrested you. Well, now you definitely say, I want my lawyer, because now what kicks in is that Miranda case that people hear about these Miranda rights, right? Look, Miranda never gave us anything. Miranda is not to be given. It is to be exercised, okay? And that means this: if they have you, number one, in custody, number two, they question you, they're supposed to give you Miranda warnings. But as long as those things don't exist, like it's consensual contact or you are free to leave,
or you are the one instigating or starting the conversation.
consent,
If you are talking to the officer, well, officer, can
what's
you
going to
just
happen?
explain
What do
to
you
me
do?
why I'm here?
Right.
What am I suspected of? What day did it happen on?
They can
Oh,
continue
well,
to
who
talk
else?
to you.
They can continue to talk to you because you are engaging in conversation with them.
Exactly.
There's no need to do that. Either they have sufficient evidence to arrest you and hold you, or they don't.
Right.
But by engaging in conversation, you may then give them additional information that could be used against you. It's not that you are admitting anything, right? Sometimes you're saying something that you think helps you, but it can be twisted to hurt you.
Right. And to protect yourself, you don't wait for them to give you any warnings. You say you want your lawyer, and then that has to stop. All right. So now I show up to court. I'm kind of scared. I don't know what to do. I find out I got to go to Department 61. I look out and I see my name on the calendar outside. I don't have a lawyer yet. What's happening now, Carm?
Well, you're going to go into the courtroom, and normally they do it by alphabetical order, but sometimes they'll go out of order just depending on the circumstances. But you will be called to stand before the judge, and the judge will read to you what your charges are. The judge is not there to listen to your explanation at that point. He is just informing you of what you have been officially charged with. And so we will remind you of this. Law enforcement may arrest you on a myriad of charges, right? They may arrest you and they may charge or book you on 10 different things. What you're actually charged with is what the DA decides the charges are going to be in a document called the complaint.
Now, the complaint should be filed before you make an official appearance, but sometimes you may show up and there's no complaint filed yet. Now, that doesn't mean you just run out of there and leave, because sometimes they want to continue the case because they're still investigating.
Or they're deciding whether or not they're going to actually file charges.
And like Carmen said, it's the DA who decides also, is it a felony? Is it a misdemeanor? And is it a lesser related charge or a greater charge?
So the officer could arrest someone on, let's say, an assault likely to cause GBI, a felony. And once the district attorney gets that officer's report and reviews that report, they could decide, no, this is really a misdemeanor battery. And that could be all that they charge.
Exactly. And so if that's the case and something has changed when you show up for your arraignment, you stay there because your name is on some calendar somewhere, or when you get a break, you may approach the bailiff and ask, my name was not on the calendar outside. Am I here today? And the bailiff could look at a no complaint filed calendar, which says, oh, they've refused to file charges. Or they may say, oh, they haven't filed charges yet, but we want you to come back in 6 weeks. So they'll give you a court slip with the date on it, and you get out of there. You're done for that day. Now, what if you get there and the judge reads you the charges, right? And the judge says, what? What is that? What else does the judge want to know after they read you the charges?
They usually ask whether or not you can afford to hire an attorney.
Ah.
And if you cannot, they offer you the services of the public defender. If there are multiple defendants in your case, here in Sacramento County and other counties in California may do it slightly differently, but one person, if there are multiple defendants, one person would be assigned or appointed the public defender, and in Sacramento County, the other defendants would be assigned a private counsel.
And private means just that these are individuals who are private lawyers who work for the county in these conflict situations, because multiple defendants creates a conflict, meaning one lawyer really should not represent all of the defendants unless the fact pattern dictates that. So the judge is going to want to know just what's your true name and do you have a lawyer? Would you like a lawyer? If you don't have one, then you may ask for one and they will appoint one for you.
And in Sacramento County, they are going to automatically assign you an attorney if you don't have an attorney, if you can't afford an attorney on a felony case. A misdemeanor case is slightly different. On a misdemeanor case, because the potential punishment that you are facing is not more than 1 year, you can actually represent yourself. And in fact, at the misdemeanor arraignment, the court may tell you or have the DA tell you what the offer is on your case and ask you right then and there if you are willing to resolve your case. Now, we never advise that you do that because you need an attorney to assess your case to determine whether or not they even have a viable case against you, whether or not you have any defenses to the charges.
And whether or not the stop that they made was valid or not.
Yes.
All the evidence can be used against you.
Because if the stop was illegal, then the evidence from that stop may be able to be suppressed. And if it's suppressed, then they don't have the evidence that they need to make the case.
And since we were puppies, we've seen this. We started out in misdemeanor court. So you see a lot of times individuals get called. They come to the podium. They're nervous. They're scared. The judge says, you're being charged with this. DA, what's the offer? And the DA says, well, I want 3 years of probation. I want 45 days. We're project and search and seizure and everything like that. And then you look around and judge says, you know what? I'll do that today right now. I'm going to take it. And you're sitting there and, well, what about this? Well, they said, da-da-da-da. Well, what about this? See, now you start asking a bunch of questions and the judge may appear to be short because they're rushing through that. The safest bet, if you have any qualm about taking some offer, always ask for a lawyer. Just ask for a lawyer or go get your own. Do not take a chance on pleading to something you have no understanding about.
And usually at that time, you haven't seen the police report.
Right.
You don't know what the officers wrote in the report. If they're witnesses, you don't know exactly what those witnesses said.
Right. And that's why you should never do that and not watch people stand up there. And the worst case scenario is when there's a DUI and they say, what's the blood alcohol content? And it's like 09 or 08, but we want a first offense DUI. And the person is scared and they take it. So you always want to get someone to look at your facts. And that means ask for your lawyer. So the arraignment is quick and easy usually. Okay, it's really quick, really fast. They want you in, they want to get you out of there. Make sure you don't leave without a slip with the next court date on it. So after arraignment, let's say I get my lawyer, right? Now, if I get my lawyer and it's a misdemeanor case, my lawyer should appear for me. I don't have to take off work or anything.
Now, I will say this. The lawyer can appear on your behalf on a misdemeanor case, but if you want to be present, if you want to hear for yourself what is going on, if you can afford to take the time off from work, it is fine for you to also be present as well. A lot of times I like for my client to be there so that they get an idea of the full process.
And with our new technology now, we're allowing people to zoom in. So you zoom right in and they find you on the waiting list and they bring you in when it's time to talk about your case. And that actually is good because you can be at work, you can be someplace and you can zoom in and listen to what's happening in your court date. And you know what? Nowadays, since COVID, felonies, you're allowed to be what's called Penal Code Section 977. Which means your lawyer can appear for you on a felony.
And that existed prior to COVID. It was just used rarely.
Right.
The judges had to specifically agree to accept the fact that you were willing to allow your attorney to appear on your behalf without your presence. And again, that's because a felony is so much more serious than a misdemeanor case and the repercussions that can come from having a felony conviction.
And you would see that a lot when individuals are from another area, out of state,
Yes.
another part of the state, this state, another part of the United States.
Mhm.
You want your client to sign a 977 waiver so that you can appear for them.
Yes.
So let's see what's happening next. There's this period of time that goes by that I'll call the discovery period. Talk to them about it, Carmen.
It's also, well, discovery, you'll hear people say discovery, and what they're talking about is police reports and other evidence in the case.
Investigations.
Yes. So it could be it usually consists of initially the police report. There could be video surveillance. There could be audio surveillance. There could be downloads of cell phones. There could be the interrogation interview.
Photographs.
If there was
video,
an interview.
yeah.
Yes, there could be photographs of the scene or of any alleged victim or the victim's injuries.
ID processes.
Yes, so the lineups.
Right.
So they still do what are known as six-pack photographic lineups. Not on every case, but in a lot of cases where a person is shown 6 photographs. One photograph is the target, meaning that person is the person who is suspected of committing the crime. Sometimes those are audio recorded. I think it's pretty rare that they're video recorded, although we wish that more of them were. If it is a physical lineup, meaning the target and other individuals are in a live lineup room and witnesses are brought in to look at them, those are videotaped.
Yes, and your lawyer should be present for one of those for sure.
Yes. Now, if it is a field show up, your lawyer will not be present because the field show up is something that is done at the scene fairly quickly after the crime occurred. And in the field show up, the suspect is the only person that is being shown. That is allowed because it is believed that the perpetrator's facial features are still fresh in the witness's mind, and they also may be able to eliminate someone if the police have detained the wrong person.
Correct. But you still watch out for those. You don't talk. You just follow the directions if you find yourself involved in one of those.
There also may be other court appearances after the arraignment where there are discussions about the case and possible negotiations. So the district attorney may extend an offer. Your attorney may talk with you about making a counteroffer. A counteroffer being something that would be an acceptable outcome to you.
This is an important period of time because this is where your case may get continued over and over and over again. And I will tell you this, if there is an offer tendered, it is the lawyer who must talk to their client about that offer. Whether the offer will be accepted or refused, the lawyer has a duty to bring that offer to their client and have their client's opinion heard, discuss the case, and then decide whether to counteroffer or to nix it all together.
Your attorney will also discuss with you possible defenses because it may be that you have a defense to your case. Now, a defense is not a guarantee that you're going to win your case, but it is a set of facts that may mean that you are not guilty of the charged offense.
When you talk to the lawyer, ask them for the jury instruction regarding the crime. The jury instruction, known as CAL-CRIM. And you can Google CAL-CRIM and find it for yourself, but you ask your lawyer for the jury instruction for the crime. In fact, if you Google CAL-CRIM assault with a deadly weapon, you'll probably come up with 875. These are important. This is the law that has to be proved in order to find you guilty. It defines the terms of the elements that they need to prove in order to find you guilty. It explains what lesser relateds are there, how to utilize words and phrases and things like that. Always ask for the CAL-CRIMs because that is the law.
And it is the law that will be given if your case does proceed to jury trial. It is the law that will be provided in a packet, a printed out packet. It is what will be provided to the jury to determine whether or not
prosecutors made their burden.
Yes.
And that's very key. And your lawyer may say, and may look at you like, oh, you know what CalCrims are and stuff like that. And you just say, yes, I do. May I have them, please? Very important step. Very important.
And again, if your attorney won't provide those to you, you can look them up. We are in a day and age of technology where everything is available at your fingertips, and so you can look up the CalCrim
Yep.
and you can look through it. It's probably over 200
Oh yeah.
pages.
Well, it's 2 volumes
Yeah.
of about 500 pages.
Each. And
But-
so you can go through there and you could actually look at the index and find the crime
Right.
and the corresponding CalCrim.
And it could be triggered by your penal code section.
And it lays out each element, and the district attorney has to prove each and every element beyond a reasonable doubt. If he can prove, if there are 4 elements to a crime and the district attorney can prove 3 of those elements but can't prove that 4th element, you are not guilty.
Exactly. So it's usually around now where now I've talked to my lawyer about the crime. I've talked to my lawyer about the CalCrims that apply. We've talked about defenses. We've talked about what investigation and discovery we want. And now comes the time to make a decision.
I'm sorry.
Yeah, there we go. Now comes the time to make a decision, because if it is a felony case, all felonies must proceed through what's called a preliminary hearing. At a preliminary hearing, the district attorney must call information, and I'll say information because it can be officers or bring documents and things, in order to show just 2 things, really. Number 1, we have the right person accused, and number 2, a crime has been described. And they can do that by hearsay, which means they'll call in the cop, not the victims, but the cops who worked on the case, and they will testify. If it's injuries and lab people are required, they may call in the lab people, or now they're calling in the cops to come in and talk about what the lab person says. And your lawyer should know that's getting very close to a line where it's double hearsay. 1 layer of hearsay is okay at a prelim. 2 layers, no good. Now,
So 1 layer, and just to explain what he means by that, 1 layer would be the officer saying, I spoke to Lab Tech Y, and they told me that they performed these specific tests. 2 layers would be the officer says, I spoke to Lab Tech Y, and he told me that Lab Tech X told him that he performed the lab procedures. So there's 2 layers, because it's not directly from one witness to the officer, but it's from one witness to another witness and then to the officer. At the preliminary hearing, there can be 1 layer, meaning the officer can testify about what witnesses have said directly to him about actions that they themselves took or that they themselves observed directly.
Now, without getting into a law school situation, I'm just going to briefly tell you about hearsay. We all hear people say that. That's only hearsay. But here's the thing about hearsay. It's an out-of-court statement. So it was made sometime out of court that's being offered in court for the truth of that statement.
So we do have some comments in the chat, and as I said, we're the society of technology, but it doesn't always work appropriately. So unfortunately, the chat is not properly displaying on our end. But one of our viewers has been kind enough to send me a screenshot of the chat, and we do have some questions in here.
All right.
Protect and Provide asked, how would anyone know if you are in jail? How would your family know or find out?
Well, with technology the way it is, you can get on the Sacramento County Sheriff's website.
Well, I think that the viewer is stating, though, you're in custody. How do you let your family know that you have been arrested?
Oh, specifically. Oh,
Yeah, if they don't know, they
right.
like you left the house that morning and they don't know
if you're
that
kidnapped
anything
or
has
anything.
happened.
Okay.
They just know you didn't come back home.
Oh, well, that individual's going to have to try to make a phone call out in order to talk about it or get somebody's attention that they're
Yes.
in jail.
And in the booking area in Sacramento County, and again, every county may be different, and it certainly may be different in other states. In Sacramento County, there are phones in the booking
Yeah.
area where a person is being held while they're waiting to be taken to a floor in the jail. So during that time, they can utilize those phones. The phones are free. The phones are conveniently free because they like when you call family members and talk about the facts of your case, how the arrest happened, what the officer did.
So never do
Those
that.
phones should really just be used to notify the family that you are safe, that you're in jail, and
Going to court, and the
yes.
next day, get me a lawyer.
Yes, that is the purpose of those phones. Not talking about your case, not talking about what happened, not talking about how you want to sue the officer.
Right, or how mad you are.
Yes, that is not the time for those kinds of conversations. Right. And the reason is those calls are being recorded. The recording says the call may be recorded. Here in Sacramento, all calls that originate from the jail are going to be recorded. And again, we're in a day and age of technology. They're recorded in digital form.
Yep.
And we get a memory drive with every single phone call on there. And if there's something that can be used against you or twisted to be used against you, they will try to do it.
Absolutely.
Now, for the family members, lawman, yes, that you were saying, if you suspect, well, my person didn't come home, right? One of the first things that people do is you may call hospitals and check to make sure that they're not in a hospital somewhere. The next thing would be to check the jails. Yes. And not just here in California, but a lot of states now. Yeah. Maybe some of the smaller states don't have the technology.
But most are online.
But they should. You should be able to go online and check to see whether or not the person has been arrested and if they're being held in custody.
Right. And then realize that when we say county jail, that we're talking about probably the sheriff's office in the county. So the sheriff would run the county jail, and they will keep an inmate locator that you can put their name in, and they can tell you whether they're in booking, they can tell you where they're located, they can tell you their next court date, all of that. So
we have a few more questions in the chat. First of all, I would like to thank the viewer Zen Mobway Walker. He asked, is the Zoom convenient for us?
Yes, it is. It's extremely convenient. It means that if you're at work, if you're driving, or just you've got something else to do, you got to stay home with your kid, that you can Zoom in and actually make your court appearance.
Yes. So I think it has made court appearances a lot easier for our clients.
Oh, yeah.
Now, I would state that the court does still want you to maintain a certain level of decorum when appearing on Zoom. They want you to try and do it from a quiet place in your home or your car. They don't want a lot of background noise, and other people should not be appearing in the Zoom with you. Additionally, you should be dressed appropriately for court. I did have a client that when I explained to him that he needed to be dressed appropriately for court, he said, it's Zoom, right? And I said, it is Zoom, but the court is still, it is still a court appearance.
Conducting business, yes.
And a certain level of decorum is required.
And we've seen the horror stories all over the United States about things like that.
Yes.
But they do enforce it here.
Brushing their teeth, appearing with their shirt off, all sorts of things that are just inappropriate for the courtroom. If you're appearing on Zoom, you should treat it the same as if you are actually appearing physically in the court, because you are.
Yes.
The video is there, it's showing you, it's being broadcast over YouTube. You want to present your best self at that time.
And understand, the judge will snap you on it. Okay, they will tell you that something's inappropriate, and you will go away into the end of the calendar.
Yes, and again, this is a person who could be making a decision about whether or not your case stays a felony or it becomes a misdemeanor.
Right. Strikes, or you never know.
Or what the sentencing would actually be. We have an additional comment that says, I like that I don't need a Black's Law Dictionary to process your presentation. We appreciate that.
Real talk.
Yeah,
that's all.
We're trying to talk in plain and simple language, and
it's conceptualized too. You get just knowing what you should do and how to ask for it.
And if we do say something that it's a term that you don't understand, there is no such thing as a bad question.
That's right.
Ask.
Because you will find in criminal law, we talk in code a lot of times,
And this is an educational program. Our purpose is to educate the public.
Right.
So there are no stupid questions.
Right.
If you have a question, ask that question. Again, I would just remind the viewers that we cannot see the chat right now. I would appreciate if the viewer that sent me the chat, if we have other comments that appear, if he would also send me a screenshot of those so we can address them as well. And again, I would remind the viewers that you can call in at 916-384-8204.
Okay.
And if you're in the chat, we would ask, or I'm sorry, if you're viewing, we would ask if you're not subscribed, that if you would subscribe, and if you would also hit that like button.
Definitely. Now, we're at that preliminary hearing stage, and the judge has to decide a couple of things, but a lot of things can happen. Strategy-wise, as the lawyer, a preliminary hearing is a good way of testing some facts. It's a good way of getting something from a felony to a misdemeanor. You can do a lot, getting an enhancement removed. You go into a preliminary hearing with a specific strategy. So you don't want to always, what they call, waive a preliminary hearing unless you're getting something for it. Quid pro quo, as we say.
Yes, and in the instance where you are waiving a preliminary hearing, usually your purpose is to try, or our purpose is to try and prevent our client from facing more serious charges.
Right.
So if you waive, normally we're asking that there be an agreement that no additional charges can be filed other than the charges that are currently filed at that moment.
Right.
Because a lot of times there are other charges that can be filed based on the fact pattern. The district attorney hasn't filed them yet,
Right.
but it doesn't mean that at some point they can't amend the complaint to allege those additional charges.
So by waiving a preliminary hearing, in return, you're agreeing that they do not add any new charges for the future. Now, at some point at the end of that preliminary hearing, a judge has to do the two things I said about this. Got to make sure that that's the right person accused. And second, that they described a crime. Not that the defense applies, not that someone's telling the truth or not. Just those two things. And then you are what's called held over for trial.
Now, the judge is assessing the credibility of any witnesses that testify at the
Sure.
preliminary hearing, but the burden of proof is so low at the preliminary hearing that it is very easy for the court to answer in the affirmative. Did a crime probably occur? Did the person accused before me probably do it? Probably is a very low burden.
Yes.
It is a very different burden than the burden that applies at the jury trial.
And we call it preponderance of the evidence. And when the way to view it is when you see the lady holding the scales, if she has a feather on one and no feather on the other, that's a preponderance. That side preponders, is weighed heavier. So that's all the judge has to rule on in terms of a preliminary hearing, whether the charge should go forward to trial, not whether it's true. Now, here comes the juice. Because now you get into a point in a session where you're about to set a jury trial. And in setting that jury trial, we're now talking about time waivers. If, in fact, you have a misdemeanor and you are in custody, you can set your trial within 30 days. If, in fact, you have a misdemeanor and you're out of custody, you can set your trial within 45 days. That way, you are not what's called waiving time. Now, waiving time may be a good thing. Waiving time may be a bad thing. It is a strategic move. For example, if I'm not done doing my investigation, if I'm not done gathering evidence, I don't want to set a time limit whereby I may not get it done. So I may want to waive time in the very beginning and set it for 45 days if I'm in custody, or 60 or whatever. And if I'm out of custody, maybe 60 days, maybe 80. It doesn't matter.
We do have another comment in the chat. Protect and Provide asks, are you allowed to represent your family if you are a lawyer, or are there rules against that? There are no specific rules that would prevent you from representing a family member, but we wouldn't advise it because usually you're too close to that person. It's the same as if you were a doctor, you were a surgeon, right?
Yeah.
It'd be extremely difficult for you to operate on one of your own family members. And what if you did do the operation and you lost that family member? Imagine how you would feel.
Exactly.
So it is always best to have someone who is not that closely connected, because they will look at it in a different fashion than someone who is a family member. When you're a family member, you're too close and you may have that tunnel vision, and that there are things that you may
Yes.
miss. You may not be applying all of your attorney skills in your analysis because your view
Your
is being
emotions.
clouded by your emotions.
Definitely. And there conflict of interest. That word, that thought, that concept. It really means that you have a relationship with the case. There is something with the co-defendant, or even another lawyer on the other side, whereby you have to say that close relationship could affect my decision making.
Or it could be that you represented a witness in the past. So I was recently contacted regarding a case, and the client was associated with another client that I had represented. And it just wouldn't be fair, because as the attorney of a person, you're going to have information that client shared with you that is confidential. And so it just wouldn't be fair. Now, there are times when a client can waive the conflicts. I usually am never ask for that, and it's my practice not to allow a client to waive a conflict. If there's a conflict, I'm going to remove myself from the case.
I think somewhat just the opposite. I have and will accept a conflict, but my clients have to sign off and agree to it. But my explanation would be that our defense is the exact same defense. Our evidence is the exact same evidence. My client may feel that, look, I really need to take this. I need her to get off, and I don't trust her having another lawyer that doesn't have that interest. So there are times whereby you may do that.
Yes. And let me say this. This man is the master, as Luther Vandross used to say about I think it was his basis. Lawman is the master. I'm the student here. He's the master. Let's make that clear.
I like Carm. But yes, so that's about conflicts. You really got to think about them and see whether or not there is something that gets in the way of the representation.
And again, I would just state, if you have a question and you want to call in a criminal law question,
yes.
Or we answer some general questions. We try and keep our focus on criminal law and how that affects the public. But you can call in at 916-384-8204.
All right.
We do have another question.
Yes, let's do a couple of those before we get to the next part of our journey.
Yes. Protect and Provide. Have either of you helped a family member or your own kids? Now, I will say this. Of course, relatives are going to call us and ask us questions, and we will answer those questions. But in terms of being the one to actually represent them, if they had an actual case charged against them, usually we're not going to do that. Now, I will say this. If it is a relative or a friend of mine, I am sending them to Lawman because I know that he is the best. This man has won cases that no one else could ever have won. This man on a murder case caught a reflection in a window that helped him win a murder case and helped save a young man's life. This is the master.
True.
I kid not. I am merely trying to snatch the pebble from his hand, and I have not been able to do it.
All right, keep on subject.
Some people don't know that reference. It's an old
the Kung
old
Fu
reference
thing,
to the show Kung Fu from
when you can snatch the pillow from my hand, now you are master. All right, but like I said, I've represented many family members, okay, and people close to me, but I've been doing this a very long time too, and if I foresee that there is a problem with that, I have no problem taking myself out and giving them an arm, okay, but it's not illegal, but it's touchy, and you really got to be careful. And sometimes the person feels far more comfortable with you, and that's why sometimes you can take it. So, we're about to go down the trial hole now. That whole area of a trial, a jury trial.
And it doesn't work like you see on the shows on TV.
Oh,
a small bit of what they do is reflective. And of
Yeah.
course, if you're watching the true crime where it's showing an actual real trial,
Right.
that is how it functions. But
Right.
the television shows, the Law and Order, where everything's wrapped up,
Yeah.
nice and neat.
60 minutes.
Yeah, it does not happen like that. It is a long, it can be
Yes.
a very long process. You have a right to have your felony trial within 60 days. Now, that did get extended because of the pandemic.
Right.
I think they kept giving extensions of
30
30-day
days,
additional
yes.
extensions. But that being said, that is not a written in stone, unmovable right.
Right.
The court can find good cause to continue it beyond that time period.
Right.
One example of good cause would be your attorney indicates they're not ready, right?
Yeah.
We might not be ready because we've been in another trial for the last 2 or 3 weeks, right? We might not be ready because the defense investigation has not completed all the tasks that need to be done. It might be that there is a witness who is unavailable.
Right.
So there are reasons, exceptions to every rule.
Right. And what's best for the case is what should be done.
Yes.
If it's going to help your case to move it, you move it. You do not rush into a jury trial unprepared, or your lawyer, especially unprepared. If your lawyer needs something, you should provide that and make sure they have that before they go forward.
And I will say this, the court can continue the case at the request of your attorney and over your objection
Yes.
if your attorney can establish good cause, and that in their expert opinion, the additional time is necessary for them to be properly prepared to represent you. And if you have a good rapport, you should try and establish a good rapport with your attorney,
Right.
because that is the only way that you're going to trust what they're telling you about their analysis of the case and needing the additional time. That's the only way you're going to trust and believe that that is what is best.
True. And it's at this point too where you have to have a trust of that lawyer. But it doesn't mean that they should dumb you down or put down on you and talk down on you. You should ask questions when you have them. Do not be afraid to ask the lawyer questions.
Do not. That is your time. I mean, your life is the life that is on the line. Your freedom is the freedom that is on the line. And no matter what happens in your case, at the end of the day, guess what? Your attorney is going home to their comfortable bed, right?
That's right.
You are the one who is at risk. So don't be afraid. Don't let the attorney brush you off. Ask those questions.
I'll tell you something. If the lawyer tells you something and it's a term of art or something that you don't fully understand, go Google it and find out about it.
Yes.
Please.
Or
let them know we need to talk about this good cause that you're going to ask for, or we need to talk about these motions that you should file.
Or again, if you are viewing our show, don't be afraid to call us and ask those questions that you have.
True.
We do have a comment from Sacramento Boy. It states, "Wow, reflections." I assume that he is reflecting on what we're saying.
Yeah, because we've been in these trenches for a very long time. There's
very long time.
Nothing we haven't seen, and some things we don't want to see. But we have to see them because we have to be able to learn from them, step in if we can do something about it.
And an informed public
yes,
is an educated public.
That's right.
And an informed public is one that cannot be taken advantage of.
Right.
And that is what we want.
Right. So this jury trial thing, Okay. I call it a thing because it morphs around, like the blob in a way. It can come in different shapes, different colors, and all kinds of things. But the first thing you got to know is this: when you set that trial, it may not go on the date that it's set. There may be reasons, many reasons, that it may be moved. So it's a fluid thing in that way. Now, at that trial, one of the first things, even getting to that trial, a court is interested in trying to settle your case. Okay? Now, settle
Not
means,
always.
well, they make an effort.
They there are some cases where
it won't settle.
there won't even be an offer. Some of the more serious cases.
And understand the offer, because we got to delineate this. It's usually coming from the district attorney. Okay? They filed the charges, they make the offer. Now, what I'm saying is, as part of a settlement, either your lawyer is going to negotiate a better offer that you would be agreed to, and you want all the terms and conditions of your offer, or there's something that's called pleading to the sheet. Okay? I also call it, and people out on the outside call it, putting yourself at the mercy of the court. Because it means this: if I've got 2 charges and the district attorney wants so much time, right? 90 days. And my lawyer is talking to the judge, and my lawyer convinces the judge it's worth 60 days. The judge will try to convince the DA, hey, how about 60 days? And the DA, no, we want 90 days or something.
But if it's just a single count, the judge has sentencing power.
Even 2 counts, 3 counts. It's called pleading to the sheet. So that means whatever is charged, if you plead to it, the judge can sentence you to whatever they want.
But I will say sometimes it's not a real option to plead to the sheet if there are multiple charges, if the crimes are serious and or violent.
Of course. So, and that's what I mean by, look, sometimes you got to go to trial because they're offering offenses that amount to life or 35, 40 years, say something like that. So you're going to trial. It's just when. And I'll tell you this, misdemeanor trials may take up to a year to get out. Get out meaning actually get a courtroom where a trial can be heard. Felony cases, 2 years, 2.5 years. So patience becomes a real skill that you've got to exercise. And you never know, okay? Strategy. Think of this. If I wait a little longer, maybe witnesses go away, maybe evidence goes away, something magical does happen. But we're not in magic land, and it doesn't happen every day. But memories could fade, things can happen. Witnesses become unavailable. So the longer the time, the better. Sometimes you want to go quickly, fast, because the witnesses are not there, but they're coming. So it's all about a strategy. But when you get to that courtroom, there will be a discussion in the back room between the DA, your lawyer, and the judge. And the judge is going to want to know, when they get to trial, here's something that people don't understand. When they get sent to trial, do you know the judge doesn't know anything about your case? Not anything about your case. They walk in there and they look and they say, well, I got this here, charges against this person. Tell me what's going on. And that's when the discussions began. The DA tells them the strength of their case. I tell them the strength of my case. We try to settle. If we can't, then the judge says, well, let's talk trial. And they start talking about time first. How long is this trial going to last? How many witnesses? When do we need the jury? You see, what should I tell them? What are our schedules like? Because they're going to mold all 3 schedules. Like, she's got a dentist appointment on Friday. I got to be somewhere on Thursday. A judge will work with you. So if you are in trial and you've got something that's so important to do, don't be afraid to tell your lawyer, hey, I've got this child support hearing that I've got to appear on Thursday afternoon.
Now, it does need to be something important. And I will say this, is that they are not as
giving
for issues with the client not being able to be there as they are for
a
us
lawyer.
As attorneys, because they realize that We do have other things that
Yes.
are.
But here's what you do if
But
you
you
got it.
certainly
You tell
ask.
your lawyer
You certainly do.
and see if they will lobby for you, you see. Because if you came to me and said, oh, I've got this going on, then maybe I've got something going on.
And you can have a medical issue,
Right.
Where sometimes with appointments with specialists, it can take anywhere.
Oh, yeah.
You're waiting for 2 to 3 months to get that appointment, and now that appointment happens to be when you're going to be in trial.
Right.
You let your attorney know
Yes.
that, and to have them try
Lobby
and
for you.
work
Yes.
with the judge to get that time off for you to be able to make that appointment.
And I'll tell
Because
you,
your
it will
health-
happen. It will happen
Yeah.
a lot of the times
Yeah,
because
your
even
health is
jurors
in-
will stop a trial because the jurors got to go to the doctor.
Your health
Okay.
is important.
Yes.
Well,
so that's
man,
the beginning.
We are
well,
getting we're not there yet.
yeah, I
but
know.
We're getting close.
We're at the edge of trial, so we'll probably have to pick it up a little bit later on what happens right after this meeting with the judge occurs, because it will occur in every trial. Note that. There'll be a moment in time you walk in the court and I walk in, and then the judge, clerk will come out and say, the judge will see you now. And then you walk in the back room in chambers.
The attorneys do. The clients
attorneys
are not allowed to
move beyond the bar,
Yeah.
so to speak. And a bar is the delineation line where you see the gate into the tables. That is called the bar, actually. So you can't move before that, and you'll see a bailiff jump up and come on and push you back if you do that.
Yeah.
So just stay behind the bar.
and they will let you know when it is time for
To
you
come
to come up
forward.
and sit at counsel table. Either your attorney will tell you,
Yep.
or the deputy or bailiff in the courtroom, or the court attendant.
If you bring friends and family, have them wait outside, because your lawyer is going to tell the bailiff to get them before the proceedings start. And if it is a waiting period where they go outside, you can tell the bailiff, I'll be outside with my family. Don't go too far, though, because you want to be ready when they come back.
And we have another comment from Sacramento Boy. I love the fact that you guys are full of information. Well, we appreciate and love the fact that you take time on your Friday to listen to the information that we are trying to provide. And we ask that you share it with people that
Yes.
you know, with people in your community, with people in the public.
And they can do that easily by bringing them to our site, right?
Yes,
And having them play this episode and stuff, or any other episode, right?
that is correct.
They're mostly an hour long, unless we get long-winded about something.
So we are at the end of this. I'm going to ask Lawman if he has a tidbit of
Something to share. Well, I'll tell you this. Look, this week has been spectacular in a lot of ways. It has been very odd in this way, that the technology has allowed me to do some things in court that has been super advantageous to my client. Meaning, body-worn cameras are gold. The things you catch on them are gold. The words that come out are gold sometimes.
Explain what you mean
By gold, okay, meaning they help me tremendously in showing that a fact may not be the fact that is written on a police report.
Oh, do you mean that you actually have caught officers who have written one thing on the police report,
Yeah.
and then when you listen and see the body
Yeah.
cam,
There's
what
something
actually
else.
happened is something completely
Yes, it is more common than you think.
different. And that is why we support the body cameras being
Oh
worn.
yes, because you will catch people talking. It is also a good week for the fact that, I managed to win a couple of stop motions, where it was clear that officers did not do or what they said they were going to do. And I'll tell you something. We play in a game that we lose most of the time. We're on the side of, we're gonna lose a lot of the time. But I've learned that you gotta speak up, you gotta stand up, and you don't fall down for anything. You ask your questions, you do it in a respectful way if you're navigating through this system, and you don't take no's for answers. your research on your own. You know, Google is an amazing thing. Amazing. Because I tell people all the time, when we were talking about these CalCrims, put in CalCrim 100. Just put it in there, and you'll be amazed what CalCrim 100 is going to tell you, because that is an instruction that's given at every trial. And it just lays out what the trial's all about, what you can and cannot do. These CalCrims are the law of California. And if you don't educate yourself and you're going through this system, you're asking to be ground up in it. And don't do that. Your life, your freedom is far more important than that. So always be diligent. Look out. Look over your shoulders, you know, for everything coming at you. Be kind to us,
Assert the
one
rights
another.
that are
Assert
given to
your
you.
rights, because the right doesn't exist unless you exercise it like a muscle. Okay? What's the scheme, Carmen? I'm pulled over. The cops want me. What should I say?
Am I free to go?
Shouldn't I say, why you pulling me over?
Nope. There is no need to have that discussion. What you need to say is, am I free to go?
Okay. And that's what I'll say. Am I free to go now, Carmen? Or are you detaining me? But it's true. It doesn't matter. If you didn't call the cops, am I free to go? And then if you're not, you want your lawyer. Name, rank, serial number, and that's it.
That's it.
And watch the show. Don't say anything. Be quiet and respectful and watch the show. All right.
All right.
Stay strong, people.
Thank you again for spending another Friday evening with Courtside with Lawman
And Carmen B.